Ever felt like you're just staring at a huge wall of text?
Mm.
You know there's something valuable in there, but you just can't face trying to climb it.
Yeah, happens all the time.
Well, that's exactly where we come in. Welcome to the deep dive. You give us the source material, and we pull out the crucial insights for you.
Think of it as your shortcut to understanding what really matters.
Exactly. And this deep dive is built specifically for you, our listener.
So today we're diving into the world of patents, intellectual property.
Now stick with us here, even if that sounds a bit, legal heavy.
Right. It can sound dry, but there's actually a really interesting story here. We've got excerpts from a court judgment. It's from the High Court at Calcutta, the Commercial Division.
Okay.
And this judgment is all about a specific case. Terex India Private Limited versus CDE Asia Ltd. and another party. It's basically an appeal.
An appeal about what?
It's an appeal against the refusal of a post-grant opposition. So someone tried to get an Indian patent canceled after it was already granted. They failed, and now they're appealing that failure.
Got it. Like a second chance to challenge the patent.
Precisely.
Okay, so a patent dispute, maybe makes you think of dusty legal files, but our mission here is, well, to cut through all that jargon.
Yeah, find the core story.
We want to get to the heart of this case. What does it tell us about these kinds of fights, and maybe why the judge had some pretty strong things to say about the first decision?
Oh, definitely. It's a peek behind the curtain of how innovation gets protected, and sometimes how it gets challenged pretty hard.
So let's get specific. What's the patent we're actually talking about?
Okay, so the patent question is Indian patent number 307249.
307249.
Okay. It was granted to a company called CDE Asia Ltd. Back on February 12th, 2019. The application itself, that was filed way back on September 3rd, 2013, application number 1033 KOLNP 2013.
And what's it for?
The title is pretty descriptive. System Device Process for Classification of Various Materials. And it includes 10 specific claims detailing how this system or process works.
Right, a system for sorting stuff. So CDE Asia gets this patent, and then Terex India Private Limited comes along.
Exactly. Terex files this post-grant opposition we mentioned, basically saying, hold on, this patent shouldn't have been granted. They wanted it revoked.
But the first decision maker, the Deputy Controller of Patents and Designs.
Yeah, that office initially sided with CDE Asia. They refused Terex opposition, and that refusal is what led to this appeal in the High Court that we're digging into.
Okay, it makes sense. So in the appeal, what was Terex arguing? What were their main points?
Well, their legal team laid out a few key things. First, they broke down the patent's claims. Claim 1, they said, is a method claim how to classify materials. And claims 2 to 4 kind of depend on that method.
Okay, process.
Then there's claim 5, that's an independent system, claim the actual device or setup for classifying materials of different sizes. And claims 6 through 10, they depend on that system claim.
All right, method claims, system claims. But what was the actual problem Terex had with them?
This is where it gets quite crucial. Terex argued that Claim 5, the system claim, describes a system with multiple parts, multiple subsystems working together.
Right.
But they argued the patent documents themselves, the specification or the drawings, they don't actually show or explain how these different parts are interconnected, how they actually work together.
Okay. So it's like listing ingredients for a cake, but forgetting the instructions on how to mix them or bake it.
That's a perfect analogy, actually, yeah. And then they brought up another major point. Prior art.
Prior art, meaning stuff that was already known.
Exactly. What was already publicly known or being used before CDE Asia even applied for their patent back in 2013. Terex argued that both the method in Claim 1 and the system in Claim 5 were, well, already out there, public knowledge, or already in use.
And if that's true,
then under Indian patent law, it shouldn't be patentable. It lacks novelty or an inventive step.
did they have evidence for this?
They did. They referenced testimony from an expert, Dr. Prabhuda Ganguly. Now, this is interesting. Dr. Ganguly apparently acknowledged that the individual components, the separate devices within CDE Asia's system, might have been known before.
Ah, so the parts themselves weren't new.
Potentially, yes. But, and this is the key nuance, Dr. Ganguly suggested, that the specific combination of these known parts, the way they were put together in the patent, might produce a new or an unexpected result.
Okay, so it's not just about the parts, but how they're combined. The invention is in the combination itself.
That's the core idea of inventive step in patent law, yes. Known parts, but maybe a novel combination. So Terex is highlighting this testimony, possibly to show CDE even admits the parts were known.
Right. What else did Terex argue?
They also talked about their own background. Terex emphasized they've been in this industry for a long time dealing with similar kinds of products they believe overlap with CDE's system in Claim 5. And they even claimed that Terex, or companies related to them, were already using the process described in Claim 1 before CDE Asia's priority date, essentially saying, hey, we're already doing this.
So, arguing prior use by themselves as well.
Correct. But their arguments didn't stop at just the patent's validity. They also really attacked the decision made by the deputy controller.
The initial decision that upheld the patent?
Yes. They heavily criticized it. They said it lacked proper reasoning, that the controller failed to explain why they were rejecting Terex's arguments.
Like what specifically?
Well, for instance, they pointed out that the controller didn't seem to address CDE Asia's own admission, or Dr. Ganguly's point that the individual components were known. And crucially, they argued the controller didn't explain why Section 3 of the Patents Act wasn't applicable.
Section 3, what's that?
That section basically says you can't patent a mere arrangement or rearrangement of known devices that just function independently in a known way, just putting existing things side by side without a new synergistic effect.
The sum is no greater than its parts kind of argument.
Kind of, yeah. Terex argued the controller just ignored this potentially relevant section.
And they had more criticisms of the controller's decision.
Oh, yes. This is where it gets quite pointed. Terex basically accused the controller of simply, copying and pasting CDE Asia's arguments directly into the decision.
Wow, really? Copy-pasting.
That was their assertion, that there was no independent thought, no independent reasoning demonstrated in the order itself. And they also claimed the controller didn't give proper weight or consideration to the recommendations made by the opposition board.
The opposition board? What's that?
It's a panel that often reviews these post-grant oppositions and provides recommendations to the controller. Terex felt their input was ignored.
Okay, so Terex is hitting hard. The patent isn't valid because it's not new or inventive, the system isn't properly described, and the initial decision upholding it was flawed, maybe even just a copy-paste job without real analysis.
That sums it up nicely. And all this led to a key procedural question in the High Court appeal, the issue of remand.
Remand. Sending it back.
Exactly. Should the case be sent back for a fresh look because the first decision was so problematic?
Did CDE Asia fight that?
Interestingly, no. CDE Asia, the patent holder, actually agreed that the case should be remanded. Both sides seemed to recognize the initial order wasn't up to scratch.
Okay, so they agreed on sending it back. What was the disagreement then?
The disagreement was about who should rehear it. Should it go back to the very same deputy controller who made the first decision? Or should it be assigned to a completely different officer for a truly fresh perspective?
Ah, right. And also, how much should be reheard? Start from scratch.
Yes. And from what stage the reconsideration should begin, that became the next point of contention.
And this brought up some specific legal rules you mentioned.
It did. They started arguing about Order XLI, Rule 25 of the Code of Civil Procedure, 1908.
Okay, Order 41, Rule 25. Sounds very specific. What's the gist?
It's a rule that guides appellate courts, higher courts, on when and how they can send a case back down to a lower court, often to take more evidence or decide on a specific issue the lower court missed.
And how did each side use it?
Well, CDE Asia argued that based on this rule and how appeals usually work in established courts, it should go back to the same authority, the original deputy controller.
Okay, keep it with the same person.
But Terex pushed back hard. They argued Order XLI Rule 25 specifically talks about appeals against decrees or orders from civil courts.
And a patent controller isn't a civil court.
Exactly. Terex argued the deputy controller's decision wasn't a formal decree in that sense. They cited a Delhi High Court case involving trademarks Promo Shirt versus Armasuis, where the court said the Registrar of Trademarks isn't a civil court. By extension, Terex argued, a deputy controller under the Patents Act operates differently too.
So that specific rule for sending cases back might not even apply here.
That was Terex's argument. And they also brought up other examples, precedents, where high courts had sent similar patent or trademark cases back to a different officer.
Why? What was the reason given in those cases?
The key phrase was avoiding the possibility of predetermination.
Predetermination. Meaning the original officer might already have their mind made up.
Precisely. The concern is that an officer who already ruled one way might even subconsciously be biased or less open to changing their mind when reviewing it again. Terex argued sending it to someone new was essential for fairness.
Okay, so lots of legal arguments flying back and forth. After all that, What did the Calcutta High Court actually decide?
The High Court came down firmly on Terex's side regarding the quality of the Deputy Controller's original order. They completely agreed it lacked proper reasoning.
They could explain the why.
Not at all. The court said it failed to meet even basic requirements for judging patentability, and the language they used was quite striking. They called the order arbitrary, suggesting it was based on subjective determination without any objective criteria. And they also used the phrase mechanical, template, and cut and paste.
Wow. Arbitrary and cut and paste. That's about as harsh as it gets from a higher court, isn't it?
It really is. It's a strong condemnation of the original decision-making process. And because the reasoning was so lacking, the High Court said they couldn't even properly review the merits of the case.
They couldn't decide if the patent was actually valid or not.
No, because the initial reasoned decision wasn't there to evaluate. They couldn't tell if the controller had properly weighed the evidence or applied the law.
So what about the remand? Did they agree with CDE Asia to send it back to the same person, or with Terex for someone new?
They sided with Terex on this, too. First, they agreed that Order XLI Rule 25, the civil procedure rule, wasn't really applicable here since it wasn't an appeal from a civil court decree.
Okay.
And then, acknowledging there's no strict rule forcing it one way or the other in the Patents Act, they made a judgment call based on fairness.
And that was?
They decided, and I'm quoting loosely here, that to avoid any complications and multiplicity of proceedings, it would be proper to remand the matter to any officer other than the officer who passed the impugned order.
So definitely a different officer.
Yes. And they specifically mentioned the reason to preclude that possibility of predetermination and ensure the litigant Terex, in this case, gets proper justice. A fair hearing.
A fresh set of eyes, basically. And where does the process restart?
It goes back to the stage of argument. So both sides get a chance to present their full case again with all the evidence, but this time to the new officer.
And any instructions for this new officer?
Yes. The High Court directed the new officer to deliver a reasoned and speaking order. That means an order that clearly lays out the logic, the evidence considered, and the legal basis for the decision. No more templates.
A proper explanation this time. Is there a deadline?
Yes, within 6 months of receiving the High Court's order.
And crucially, did the High Court give any hint about whether they thought the patent itself was good or bad?
No, they were very clear on that. They explicitly stated they were not expressing any opinion on the merits of the patent application or the opposition. That's entirely for the new officer to decide after hearing the arguments.
Okay, let's try and wrap this up then. We have this patent for sorting materials, CDE Asia's patent. Terex challenged it, saying it wasn't new, maybe just known parts put together, and wasn't explained well.
Right. And their challenge was initially rejected.
But the High Court slammed that rejection, calling it arbitrary, basically saying it had no real reasoning.
Yeah.
A cut-and-paste job, even.
Strong words, yes.
So the High Court sends the whole thing back, not to the same person, but to a new patent officer to avoid bias. They need to hear the arguments again and make a properly reasoned decision this time.
That's the gist of it. And I think the real aha moment here, a big takeaway, is how much the High Court emphasized the need for reasoned judgments.
The importance of explaining the why.
Exactly, especially in administrative decisions like this. For you, the listener, wanting clear information, you can see why a decision without explanation is just, well, useless, right? You can't understand it. You can't really challenge it properly.
Absolutely. It undermines the whole process.
Yeah.
It shows that even in something technical like patents, fundamental principles like fairness, transparency, due process, they're critical.
For sure. And the wider implication is that getting a patent isn't necessarily the end of the story. It can be challenged, and the process needs to hold up to scrutiny with clear justifications needed at each stage.
It really makes you think, doesn't it?
It does. And maybe here's something for you to chew on. How important is that why behind any decision you come across? Whether it's, something big like a legal ruling or just a news headline or even something someone tells you at work.
Does that lack of clear reasoning make you trust it less, even if you agree with the outcome?
Right. And what does that suggest about how we should evaluate the information that bombards us every day? How much do we really demand that clear reasoning? Definitely something to ponder.